Jailed Nigerian militant Roils, South Africa's Judiciary. How South Africa's involvement in the Niger Delta poses a dilemma for the ANC government. Two rulings in quick succession by South Africa's judiciary have brought the spotlight back on Henry Okah, the leader of the movement for the emancipation of the Niger Delta, militant group in Nigeria. One ruling was made by the Judicial Conduct Committee, JCC, and the other by the Constitutional Court, both concerning Okah, who is currently serving a 24-year jail term in South Africa for car bombings that left several people dead in Nigeria more than 14 years ago. On February 12th, a three-member panel of the JCC voided an earlier dismissal of a complaint by Okah, alleging that documents he filed as part of his appeal process were tampered with at the instigation of erstwhile South African Chief Justice Raymond Zondo. The dismissal of the complaint is set aside and the matter is referred to the acting chairperson for an inquiry under Section 17 of the Act, the justices said cryptically in their ruling. It was a euphemism for saying that an investigation will now be launched into the complaint as provided for by the relevant section of South Africa's Judicial Services Commission Act. Okah specifically accused Zondo of causing officials in the Registrar's Office of South Africa's top court to alter the contents of his filings and ensure his application failed. It did fail at the time. In its ruling, the JCC noted that Zondo had spurned the opportunity given him to defend himself against Okah's allegations. The inquiry, consequently directed, will either confirm or dismiss them. If confirmed, of course, punitive sanctions could follow. Zondo is involved in another controversy regarding the validity of evidence tabled before him as the chairperson of the judicial inquiry into state capture under former President Jacob Zuma after he admitted this January that at least one piece of evidence was dodgy. Less than a week after the JCC ruling, the Constitutional Court on February 18th delivered its verdicts on two separate applications brought by Okah that sought the rescission of two orders of that court, which Okah contended had been obtained by sleight of hand. The Constitutional Court refused to give those requests but granted condonation, a legal term that means the court accepted his reasons for filing those applications late. While Okah may not seek a review of the Constitutional Court's 2018 appeal judgment, his complaints will now be subjected to an inquiry as directed by the JCC. Okah is also entitled to file another application for the determination of the lawfulness of his detention on an urgent basis, a step he now wants to pursue. It is a right derived from South Africa's adoption of Article 9 of the International Covenant on Civil and Political Rights. The provision gives a detained person, whether awaiting trial or sentenced, an opportunity to challenge such imprisonment where substantial procedural irregularities have occurred in the legal proceedings. What makes this development quite significant is that the JCC is composed of top justices of the Constitutional Court, the highest court in the land, inclusive of the Chief Justice, her deputy, and four other justices. A minimum of 3 members sit on a JCC panel at a time. The current Chief Justice, Mandisa Maya, had looked into Okah's complaint as chairperson of the JCC and dismissed it. That decision has now been set aside by her colleagues, who, in unanimously reinstating Okah's complaints, called for an investigation. They had to overcome whatever reservations they may have harbored about adjudicating a complaint against one of their own, and it certainly took a lot of gumption for them to uphold Okah's complaint and decide to subject the system over which they preside to some accountability. In the beginning, Okah was arrested in South Africa on the 2nd of October 2010, where he was a permanent resident regarding 2 bombings carried out in Nigeria by MEND, of which he was found to be the leader. MEND, which took responsibility for the bombings, was fighting the government of Nigeria and international oil companies in a still unresolved armed conflict for polluting the region and leaving its inhabitants impoverished. The group wants more of the Delta region's wealth for its people. He was tried and sentenced to an effective 24-year term of imprisonment because South African law allows local prosecution of terrorism committed abroad. The South African authorities were bent on convicting him and in their hurry committed procedural irregularities that are fatal to the case against him, according to Okah. It started with the September 30th, 2010 nighttime raid of his home in Johannesburg by a team composed of various units of the South African Police Services, led by officers of the Directorate of Priority Crimes Investigation, otherwise known as the Hawks, recalled Okah. They were accompanied by members of the South African branch of Interpol, who had the exclusive right to effect the arrest of a foreign fugitive from justice as prescribed in Section 15.6 of South Africa's Protection of Constitutional Democracy Against Terrorist and Related Activities Act, number 33 of 2004, the anti-terrorism law. The intention was to effect Okah's arrest based on information said to have been received about his involvement in terrorist activities in Nigeria. In my presence, Interpol refused to effect my arrest for the reason that I was not wanted by any state, and thereafter left my residence, he said. Interpol was insisting on compliance with Section 15.5 of the anti-terrorism law, requiring that a complaint be received from a concerned foreign state before an arrest. An 11-hour search of Okah's home that ensued yielded nothing incriminating before the Hawks left, he said. Sifaiwe Clement Mabaso, a lieutenant colonel attached to the Interpol extradition desk in Pretoria, stated in an affidavit that he had explained to members of the Hawks that there was neither an extradition treaty between Nigeria and South Africa nor an arrest warrant for Okah, for which reason an arrest could not be effected. The presence of the Interpol, as he further stated, was to verify Okah's address if a procedurally valid arrest was to be effected. This never happened, as on the day of Okah's arrest, the Nigerian government notified Interpol that Okah's arrest was not being sought. 2 days later, the Hawks returned to arrest Okah on a warrant issued by a magistrate based on Section 43 of the South African Criminal Procedure Act, CPA, contrary to the provisions of the anti-terrorism statute. Okah contends that this made his arrest unlawful and presents prima facie grounds for examining and determining the legality of his detention. Okah further argues that the extraterritorial application of South Africa's domestic anti-terrorism statute is confined to acts of terrorism committed in peacetime. In such cases, there must be evidence of a sufficient connection between the crime and South Africa. Okah said there was no such connection between South Africa and the car bombs in Nigeria. South African law recognizes non-international armed conflicts, such as the situation in the Niger Delta, based on which the appropriate legislation for his trial would have been the domesticated ICC Act number 27 of 2002. But Okah is of the view it would have been virtually impossible to secure a conviction under that law because it has no provision for the crime of conspiracy to commit terrorism, and he was nowhere near the crime scene. I was deliberately prosecuted and tried under the wrong law to ensure a conviction, he said. At the trial itself, Okah had sought the protection of an exclusionary clause that exempts from the classification as terrorism acts of violence a group committed in furtherance of their legitimate right to national liberation, self-determination, and independence against colonialism or occupation or aggression or domination by alien or foreign forces. But the South African High Court rejected this defense, partly on the ground that Okah had accepted the Nigerian government's amnesty, and further that the court did not recognize the Niger Delta conflict as being a fight for self-determination or against colonial or foreign occupation. International humanitarian law prohibits the intervention by foreign states for any reason whatsoever in an armed conflict occurring in another sovereign nation, Okah pointed out. South African courts usurped the power to determine the nature of the conflict occurring in Nigeria and adjudicate the alleged crimes committed within the context of such a conflict, a responsibility envisaged by the law to be the exclusive preserve of the ICC. In the course of his trial, Okah complained that his access to his witnesses, some of whom were incarcerated in Nigeria, was impeded by the Nigerian government. State witnesses were flown to South Africa and put in luxury hotels at the Nigerian government's expense. Okah was required to bear the full cost of bringing over his witnesses, making the trial, on the balance of resources, anything but fair. The trial judge acknowledged the fact that my defense was being sabotaged by the Nigerian government and ordered that I close my case by December 3rd, 2012. If my access to witnesses was still impeded by the Nigerian government, said Okah, I did as ordered, and he convicted me. High Court, Johannesburg, for reasons Okah says he is yet to fathom, wrote that the Nigerian government had done its utmost to assist me in obtaining the presence in court of my witnesses, and it was I who rejected all such offers of assistance. The South African Constitutional Court would later rely on this falsehood to dismiss his 2018 appeal, he said. It was unclear at the outset what South Africa aimed to achieve by Okah's trial. On the surface, it appeared as though driven by altruism, a moral abhorrence for acts of terrorism, and a spirit of fraternal relations given the support lent to the ruling African National Congress, ANC, in its fight against apartheid, the Church Street bombing. It is noteworthy that the ANC had used methods such as MENS in its fight against the racist minority regime, a fact that dents its moral posturing. On May 20th, 1983, Umkhonto we Sizwe MK, the armed wing of the ANC, led at various times by Joe Slovo, Chris Hani, and former President Jacob Zuma, set off a car bomb outside the headquarters of the South African Air Force on Church Street, Pretoria. The blast killed 19 people, 11 of whom were said to be military personnel and the rest innocent bystanders and civilians on a busy street. The attack was said to have been authorized by Oliver Tambo, who at the time was the ANC president. Discussing the incident in his autobiography, Nelson Mandela said it illustrated the reason why taking up arms was a very difficult choice. At the Truth and Reconciliation Commission hearings in 1997 to 1998, 10 MK operatives, including Abu Bakr Ismail, the commander of the group that carried out the bombing, applied for amnesty, which was granted. Even more recently, after the Palestinian militant group Hamas carried out the October 7th, 2023 attacks on Israel that sparked a brutal military response, the ANC-led government spoke up in defense of Hamas and the Palestinians. The Cyril Ramaphosa-led government went on to file complaints of genocide against Israel at the ICC at The Hague in the Netherlands, for which warrants of arrest have been issued against Israel's Prime Minister Netanyahu and other senior members of his government, as well as Hamas leaders. For the Niger Delta, South Africa has taken a different pro-government tack, despite the region being in the news for decades on account of oil production by a partnership of the government and oil majors that turned the oil region into the most polluted place on earth, creating a rolling insurgency by its disgruntled ethnic minorities. Indeed, the Niger Delta was the reason relations between South Africa and Nigeria went sour in 1995 after then-President Mandela had criticized Nigerian dictator General Sani Abacha for the execution of 9 Ogoni rights activists, including the writer Ken Saro-Wiwa, that campaigned against environmental damage caused by the oil companies. Before then, there had been several military and police massacres, such as that on the village of Umuechem in Rivers State in 1993 carried out in reprisal against a protest against the Shell plc. Lieutenant Colonel Paul Okuntimo, a military commander deployed to the Ogoni areas in the 1990s, once recalled early morning attacks that commenced with lobbing a few hand grenades at sleepy villagers, then mowing them down with machine guns and assault rifles as they fled the mayhem in their pajamas and underwear. South Africa couldn't have been unaware of the Nigerian military's invasion of the town of Odi in November 1999, when an entire town in the Niger Delta was destroyed by troops in a reprisal attack after an armed group killed 12 policemen in an ambush. It was largely in response to such scorched earth military tactics that a full-blown insurgency developed in Nigeria's oil region by 2005, though troops have for the past 3 decades continuously been stationed in the region. For the South African judiciary to find that there was no struggle for self-determination and against oppression and injustice in the Niger Delta region of Nigeria was a deliberate subjective choice, which could be the result of a conservative South African bench, the remaining vestiges of an apartheid era still beholden to laws protecting private property. One of the charges for which Okah was convicted stemmed from a threat by MEND to target South African investments in Nigeria following his arrest. Justice Claassen, as the sentencing ruling shows, struggled with the political nature of the crime. The accused, however, has not accepted responsibility for any of the crimes committed, nor has he shown remorse, the judge wrote. There was, however, evidence before this court that he is regarded as a leader in Nigeria and in particular in the Niger Delta. Claassen also noted that militancy in the Niger Delta was caused by the failure of the government to adequately promote the interests of the community in that area, and the accused became the leader of this struggle. While acknowledging that a militant political struggle could lead to bloodshed and tragedy, it only got him to spare Okah from life in jail, the maximum sentence for the offense. Obviously, South Africa's empathy didn't lie with West African villagers fighting a losing battle against the government and oil multinationals. Besides, there appeared to be a willingness on the part of the ANC government, then headed by Jacob Zuma, to work with Nigeria to ensure Okah's conviction. The jailed militant thinks that corrupt inducements were a major incentive to the South African government, and the appearance of altruism is but a front. The award of an oil license in Nigeria to South African company SAC Oil, now Ifora Energy, counts among the benefits gained from prosecuting him there, Okah said. A former top official of the prosecuting authority is currently a director of the company, he alleged. In a September 2014 incident, a private jet owned by Nigerian Pentecostal preacher Ayo Oritsejafor was intercepted at a South African airport with close to $10 million. Nigerian officials said at the time that the money was meant to buy arms to fight the Islamist insurgency raging in the country's north. Okah said they were bribes meant for senior officials in the Zuma government. If it truly there was an intention to purchase arms, it would have been a transaction effected through the Nigerian Central Bank, and a responsible Nigerian government official would have been aboard that aircraft, said Okah. No government procures arms with cash carried around in suitcases. And besides, what of the panel that recommended the amnesty program. No significant effort was further made to implement the second part of the amnesty package, which involved cleanup of the polluted region and steps to return some of the wealth to the locals. Okah was among those who objected and raised questions about this failure to address the core issues that led to the unrest in the Delta region. Okah recalled that on his release from detention in Nigeria after facing treason charges, he was offered an oil license, which he rejected. President Yar'Adua was visibly bewildered. Okah said that he wanted nothing for himself. He restricted his interactions with Yar'Adua to Niger Delta issues. While some militant leaders took up government contracts, others ventured into politics. Farah Dagogo, who had been a prominent MEND commander, was elected into the Rivers State Legislature for 2 terms. Dokubo Asari has revealed being on the retainer of oil companies, the government, and politicians, operating primarily as a private military contractor. Ateke Tom became a traditional chief, and Tom Polo got perhaps the biggest pipeline security contract with an annual value of hundreds of millions of US dollars. I alone sought no personal benefit and accepted none, said Okah. My preoccupation then, and to this day, remains justice for all the inhabitants of the Niger Delta. That was the basis for armed struggle and not self-gratification. With the government turning a deaf ear to the real issues affecting the region, there was a resumption of attacks claimed by MEND. The March 2010 bombing in the southern town of Warri and the October 2010 bombing in Abuja, for which Okah was convicted in South Africa, were among the renewed attacks. In his absence, the situation in the Niger Delta deteriorated rather than improve. As the settled militant commanders withdrew to their city mansions, many fighters previously under their command were abandoned to their own devices in the creeks. They made their living as best they could. So, while there was a decline in fighting and attacks on oil workers, there was a surge in sabotage and oil theft, disrupting Nigeria's oil exports. Under President Jonathan, all seemed to be going well until the opposition won the 2015 elections, with Muhammadu Buhari being president. Buhari, in his military dictator style, began threatening severe action against recalcitrant fighters in the Niger Delta. He revoked Tompolo's contract and declared him wanted for fraud, forcing the former militant leader underground. This resulted in a resurgence of attacks on crude oil pumping stations that drastically cut oil exports at a time of low prices, forcing Nigeria into its first recession in 25 years. Production and exports recovered somewhat after Buhari sued for peace with militants and engaged community leaders and elders to persuade the assailants to sheath their swords. The attacks did reduce by 2017, but then it also became obvious that Buhari had lost control of the Niger Delta. He had no clear plan to end the violence and develop the region to gainfully absorb its teeming population. At the same time, the Nigerian military was unable to overcome the myriad of armed groups that stalked the creeks of the Niger Delta, now focused on piracy in Nigeria's coastal waters and tapping crude oil from pipelines for sale to vessels waiting offshore, or for illegal local refining. According to anecdotal accounts and subsequent confirmation by military authorities, even troops sent to the region got involved, with their officers working with criminal gangs in rackets for self-enrichment. Toward the end of Buhari's second term, after Tompolo was acquitted in court of the charges against him, he was now engaged by the Nigerian National Petroleum Company to help check the illegal activities of troops working with oil thieves in the region, in the hope of recovering from dwindling oil production. This has had limited impact. Illegal oil activities became so widespread and seemingly uncontrollable that from 2020, daily output that had stayed above 2 million barrels for the previous 3 decades was at an average of 1.3 million barrels per day for the next 4 years. Nigeria was unable to meet its OPEC export quota and did so for the first time last December. The Niger Delta environment became the worse for it as thousands of cottage refineries emerged across the entire region, sending plumes of dark smoke into the sky as they boiled oil, with the sludge from this crude refining process endlessly spewed into surrounding rivers, streams, and swamps. The unresolved Niger Delta conflict remains the one single factor that threw a spanner in Nigeria's economic works, sending it downhill as oil exports, the major source of the Nigerian state's revenue and foreign income, plunged. Even the use of former militants such as Tom Polo and Dokubo Asari proved grossly inadequate, if not spectacular failures. President Tinubu has indicated his inclination to resolve the oil region's outstanding issues by his recent meeting with Ogoni community leaders. Getting the entire Niger Delta region on board is a bigger challenge he needs to deal with: legal battles. For Okah, the last 14 years of his jail time has also been a period of relentless legal battles, despite being held in solitary confinement for 10 of those years. The case progressed from the High Court through the Supreme Court of Appeals to the Constitutional Court, the highest in the land. After having presumably dispensed of the appeal in 2018, the South African judiciary suddenly finds itself examining its conduct in the Okah case. For the South African government, Okah's presence in its prison is a source of judicial controversy and a diplomatic bone in the throat it is struggling to deal with. Okah said he has rejected repeated offers of parole because he intends to seek a judicial resolution to his allegations of unlawful arrest. For now, it appears to be a race between him and the authorities as Okah seeks a fresh application with the Constitutional Court to determine the lawfulness of his arrest, while South Africa's correctional services seek ways to foist a parole on him. Talks between Nigerian President Tinubu and South African President Ramaphosa last year also touched on the Okah case, according to sources close to the discussions. I understand there was a very lengthy meeting recently about what to do about me, Okah said. Some suggested deporting me to Nigeria without the formality of parole, while others spoke against it. But they want me out by all means. Now that it has become clear that the ex-militants cannot rescue Nigeria's oil production, the Tinubu government may yet find talking to Okah, the one person who is still respected by the uncontrolled armed groups in the oil region, a useful step toward lasting peace that will finally end the bleeding of the Niger Delta.